Okay, I believe we have everyone present. I thank you. Mr. Mann, my understanding is you represent the appellant in this case, so I will proffer the question to you. Did you wish to reserve any time for rebuttal?
Yes, thank you, Your Honor. I would like to reserve 5 minutes.
Okay. I will try to interrupt your presentation as delicately as I can at about that moment to let you know. And with that, we are ready to begin, counsel.
Good morning, Your Honors, and may it please the court, Jonathan Mann of Bresky Law on behalf of the appellant and cross-appellee Gordon Wild. I would like to reserve 5 minutes as I stated. As the court's aware, we've raised 2 points in this appeal, not including the cross appeal, of course. The first is that the trial court erred in entering final judgment against Mr. Wild, where he had met his burden to show breach of contract. A breach of contract requires that there be a valid contract, breach, and damages shown. Here, there was no dispute that there was a valid contract. As to the breach, the contract called for substantial completion by November 30th of 2017, and it was not disputed that the contract was not substantially completed by that date. As we've argued, that term was material and went to the essence of the contract.
But Mr. Mann here, don't we have to find, in order for there to have been a material breach, that the contract, that their deadline here was, well, that there was time was of the essence, in other words?
Yes, Your Honor, and here
Okay.
we would submit it was.
And but there are provisions in the agreement that are lacking that would reflect that time was of the essence. We don't have any provision that talks about a penalty in the event the contractor didn't finish by that specific date, right?
That's correct. However, given the hardship to Mr. Wild and the nature of the contract, that's what we would base our argument that time was of the essence in this case.
But then we have the added factor that there was a hurricane that happened that delayed, and there was testimony to this effect that the contractor was having problems with subs coming and completing because they were going off to get more money on other jobs, right? So doesn't paragraph 12A excuse that and excuse that there was any sort of material breach here?
We would submit that it does not. The testimony at trial regarding the hurricane was exceedingly general in terms of its effects, and my client is certainly sensitive to the devastating effects of Hurricane Irma, but there was a 6-month window for completion of the contract, and even after Irma struck, Mr. DeVisi, not counsel, but the principal of Tri-Town, testified that he had workers back on site by October 5th. In addition to that, as Your Honor mentioned, there was evidence that Tri-Town simply chose to prioritize other work and was making quote unquote crazy money hiring new employees and pulling a record number of new permits rather than devoting any effort to completing Mr. Wild's job. The other point that I'd like to make related to that, it's the other defense, and it's related. It's the other defense that that Tri-Town asserted at trial was that Nicole Clapper of the plans was also to blame for Tri-Town's failure to complete the contract by the date for substantial completion. And we submit as a matter of law that defense had to fail because there was never any competent substantial evidence that Mr. Wild had designated her as his agent, and which you need to either have a parent agency authority or actual agency authority. The testimony from Mr. DeVisi at trial was, well, I relied on what Miss Clapper, the purported agent, I relied on her behavior in concluding that she was Mr. Wild's agent. Well, that as a matter of law is insufficient to establish that someone is a purported agent for a principal. And so we submit that Tri-Town's two defenses fail. Tri-Town did have the burden of proving that agency, and that the testimony, the evidence that came in on that point was insufficient, given that the purported actions of the agent are not enough. I mean, Mr. DeVisi's testimony was, it was my own opinion that he was relying on Nicole Claproot, he being Mr. Wild, was relying on Nicole Claproot to make decisions. Ms. Claproot testified clearly that she prepared the plans prior to the contract so that Mr. Wild could obtain a fixed price contract for the work, which was important to him. But that after that, her responsibility was essentially done. She was available to help clarify her plans, but she was not making decisions for Mr. Wild on the project like a project manager. The contract was only between Tri-Town and Mr. Wild, and Tri-Town had a responsibility to contact Mr. Wild if there were problems that it was having.
Weren't there conversations between the principals that suggested that the lady was supposed to be Mr. Wild's designee at meetings with the contractor and did not attend?
There was some testimony to that extent, or there was some testimony on that point, correct, Your Honor? But again,
Does it not, some sort of conflict as to whether she was deputized as some way his agent? Does it not?
I don't believe it does, given the scope of her involvement in the project. I think that's the best way I can answer that, Your Honor. Is that even I'll leave that as it is. I think that her involvement is what it was testified to be. Never did, even with the arrangement of meetings, it was again simply to clarify what her plans were, and her plans were limited to what an interior designer can do.
Mr. Mann, and here your client actually terminated the work of Tri-Town before construction actually stopped, because the association actually extended these deadlines in light of the hurricane, and your client chose to terminate the work of the contractor before that deadline.
In November of 2017, Mr. Wild, so the construction deadline for the condominium was eventually extended to November 30th, and then slightly, I think, beyond. But in November of 2017, Mr. Wild was attempting to get set up meetings and getting in contact with Mr. DeVisi from Tri-Town, and was really getting nowhere in doing so. Mr. Wild wanted a schedule for completion of the project, and he never got one. He wanted to meet with Tri-Town and agents from Tri-Town, and he never was able to. And so, faced with what he was faced with, he had after the expiration of November 30th, he felt that he had no choice but to decide that it was Tri-Town that didn't want to move forward. We don't really know what could have happened if there was further communication between the parties after that. I'll touch on damages. Our position is that we established our damages by the testimony from Mr. Karasi, who missed to complete the project, and that under as a matter of law, the cases we've cited in our brief, the Grossman case, the Smith case, and a case called Temple Beth Shalom, support that the reasonable cost of construction and completion in accordance with the contract is an appropriate measure of a plaintiff's damages for breach of contract for unfinished construction. And that was what Mr. Karasi's testimony was here, was that he took a look at the project, essentially took a look at the unfinished project, took a look at the plan and said, and then testified as to how much it was going to cost to complete the work under the same scope that Tri-Town had been working on. And then again, as to damages, the other component of damages that Mr. Wild had sought was $30,000 in loss of use value, because again, he was essentially stuck with a condominium that was unusable by him and unrentable by him for the season. He limited it to the one season, but his testimony, the owner's test, he as the owner, as a matter of law, we submit that his testimony was sufficient regarding, he testified his knowledge of the property because he had owned it since 1998. He testified to the amount that those units go for and that they rent easily, as his calculation.
Was there not testimony that in the past he had not taken the opportunity to rent it out?
Yes, that's true, Your Honor. There is such testimony, but we think that he still, if he was unable to use it, that rental value is still an accurate measure of calculating damages. I'll move on to the second issue that we raised in our initial brief, which was that the trial court did not make specific factual findings or findings of law, and that it hampers meaningful appellate review in the matter.
But how does it hamper it when we're here on de novo? I mean, we're here to, we have the whole record to look at, right? We have the transcript of the proceedings to look at. So we actually have the record before us. So how were we hampered by that?
We would submit that it's difficult to tell from the final judgment that we have what the trial court's conclusion was, based on the argument that I just made, that the contract had set a time for completion. That date was not complied with by Tri-Town. The arguments regarding the failure of Tri-Town's affirmative defenses, that we don't have a finding that from the court that Tri-Town proved any of its affirmative defenses, and that I also will want to touch on in the cross appeal. But all we've got is the finding, if you can, conclusion, I suppose you'd say, that both parties failed to meet their burdens of proof.
Mr. Mann, let me ask you a question with regard to your second argument, that we remanded back for the trial court to make findings. And let's assume, for the purposes of the conversation, I agree with the ends. My question is the means. Is there a statute that authorizes this court to issue such an order? We know in divorce cases, the legislature has required and demanded a number of findings to be made. So when we remand on divorce cases, we are using a legislative, a grant of authority and a statute. So I did not find one. Were you able to find one that requires this?
No, Your Honor. My argument was not that findings are like I often see in other.
I looked at the case from the First District by Judge Lewis, and I looked way back to the Fourth DCA by then Judge Anstead, and I'm looking for the source of legal authority to reach that pronouncement. There's not a rule that I could find of judicial procedure promulgated by the Supreme Court. So I'm still lacking authority. Maybe, I don't mean this to be humorous, but I looked at one of the dissenters. He made a very fine point. If this court were to issue a PCA, does the Supreme Court have authority to order us to make findings or to write an opinion? They would if they promulgated a rule, wouldn't they? But they haven't yet. And so that's my concern, is where is the authority to do so? And I'm reluctant to use the phrase the court's inherent authority. because I don't know what the limits are of that. And as a branch of government, I want to stay within what they call Wrigley Field, the friendly confines of my authority.
I understand, Your Honor.
That's my concern. And I don't know that we have to address it in your case, but I don't want you to feel that I've ambushed anybody because you don't know what's going to happen. That is my concern.
I understand, Your Honor. I understand your concern. And
if you needed to, there's another case out of Collier County called Naples Estates versus Gatsby that came out in December, and you know who to blame because I wrote it. And that was part of the concern. We didn't have findings in that case either from Collier County. And I went through the various forms of the traditional rules that we have. And that's why I guess you could say I'm a little bit more alerted to the issue because I had to deal with it recently. And there's that notion of recency and primacy. So
I understand.
I don't want to take up any more of your time because we're at 13, but I want to let you know where I was coming from if when it's time for me to look at that issue.
I understand, Your Honor, and I would want to take a quick look again at the cases that I cited because I think that in support of this issue, because I'm pretty certain that in those cases there were not. In fact, I think one of the
there wasn't much of a discussion in either one of them about it. There are ones in divorce cases. You're absolutely right, but there's a statute.
Right. So I'll move on to address the cross appeal at this time, rather than wait. As the court's aware, the appellee cross appellant has argued that the trial court erred in denying their motion for attorney's fees based on a prevailing party prevailing party clause. Our position in response to that is that in a case such as this, now this is, keep in mind, this is assuming that the court decides to affirm as to the issues we've raised on appeal. Our contention is that the trial court was within its discretion in a case such as this to deny attorney's fees, basically to decline to find a prevailing party and to deny attorney's fees. We argued the Moritz case from the Florida Supreme Court. I think that the KCIN Inc. v. CanPro Investments case, which is 675 Southern 2nd 222, is particularly relevant and appropriate and on point regarding this issue where, as we discussed, the final judgment simply says both parties failed to meet their burden. Does not say defendant prevailed on its affirmative defenses, simply both parties failed to meet their burden. And to paraphrase, I would say the two parties, you guys fought to a draw. I'm going to not award attorney's fees to either
As
side.
promised, I will let you know you're at 15.
Oh, thank you, Your Honor. And so in that case, in KCIM, the court said prevailing party attorney's fees are just and proper in the majority of contract litigation. We are concerned, however, with contracts that fail as a result of fault by both contracting parties. And a rule which requires an award of prevailing party attorney fees in all cases may result in an unjust reward to a party whose conduct caused the failure of the contract. And so that, rather than a situation such as the Carrollwood case, which I know opposing counsel is relying on, is more appropriate and more on point for this case. I will save the rest of my time, please, Your Honor. Thank you.
Thank you, counsel. Okay, I'm not muted. All right. Mr. DeVries, did I pronounce that correctly, sir?
Yes, you did.
Thank you. I try hard. I know people have some difficulty with mine, so I try to be reciprocally sensitive. You may begin, counsel.
Thank you very much. Good morning, Your Honors. Matt DeVries on behalf of the appellee and cross appellant Tri-Time Construction LLC. I'd like to begin with the time is of the essence argument, and Judge Smith pointed it out during Mr. Mann's argument, but the principal case is called Atlanta Jet. It's from the 4th District Court of Appeal in 2004. And the Atlanta Jet case laid out 4 circumstances where time could potentially be of the essence in connection with a contract. Circumstance 1 and 4 are not at issue in this appeal. Circumstance 1 is if the contract actually says time is of the essence. Circumstance 4 is if the non-defaulting party provides a certain notice, which it's undisputed that Mr. Wild did not provide that notice in this particular case. Circumstance 2 is time could potentially be of the essence if it's determined from the nature of the contract. So you do have the November 30th, 2017 deadline for substantial completion. As the court has recognized, you also have section 2 of the contract, which says the work will be completed subject to reasonable delays. And you also have section 12A, which is the force majeure provision. It's a very, very broad provision on its face, specifically includes hurricanes, supply shortages, delays, and things of that nature. Mr. Mann said the testimony about Hurricane Irma was exceedingly general at the trial. I was trial counsel. That is absolutely not true. The record would be transcript pages 263 to 291. There was a substantial amount of testimony at the trial related to the specific impact of Hurricane Irma on Tri-Town's ability to achieve substantial completion. If we look back at the second circumstance under the Atlanta Jet case as to whether time is of the essence, I've mentioned the contractual provisions, section 2 and 12A. You also have the Command versus Maffa case from the 4th District Court of Appeal in 2012. That case specifically says just because there's a deadline in the contract does not make time of the essence. If you go to the third circumstance in the Atlanta Jet case, time could potentially be of the essence if treating time as non-essential would cause a hardship. So the testimony at the trial, as the court recognized, it was from Julie Williams, the building manager of the association, that the association allowed construction work through mid-January of 2018 based on Hurricane Irma. And the association allows non-loud cut construction work, things such as painting and similar items, all year round. The court could look to the supplemental record, pages 330 through 332, for that specific testimony. You also had testimony at the trial, both from Mark DeVries and from Wild's engineering expert himself. His name was Thomas Conracode, that the remaining work could have been completed within 35 to 45 days. The court recognized Mr. Wild terminated the contract in early December, and early December to mid-January 2018 clearly would have fallen within that particular time period. The court could look to page 169 of the supplemental record, which is the trial transcript, and pages 296 to 298 for that particular testimony. Another interesting fact that came out at the trial, and this is in page 90 of the supplemental record, the trial transcript, Mr. Wild had not completed the construction work as of the date of the trial. The case was tried in October of 2019. So he had the whole year in 2018 and then several months in 2019. The construction window is out of season, typically begins in May and ends in November or December. So, I mean, he had a period of about 24 months, 2 years. He did not complete the construction work, and that clearly goes or vitiates the third element under the Atlanta Jet case. If the court were to find that time was of the essence, there was, again, a substantial amount of testimony and evidence presented at the trial related to the specific impact that Hurricane Irma and Nicole Clapperud's failure had on Tri-Town's ability to achieve substantial completion. I would, again, point the court to pages 263 through 291 of the supplemental record, which is the trial transcript. Ms. Clapperud testified Hurricane Irma caused delays. That's at page 183. And then you had a substantial amount of testimony from Mark DeVries himself, who's the principal, founder, and owner of Tri-Town Construction. And he essentially walked through the impact of Hurricane Irma, both before the hurricane actually hit, and you had testimony at the trial that literally nobody really knew what this storm was going to bring. You would watch the news and they would say there's going to be a 10 to 15 foot storm surge. The entire city of Naples is going to be underwater. You couldn't find a flight out of Fort Myers Airport. I mean, it was total chaos, and that was just before the impact of the hurricane. Then you get the hurricane in September of 2017. The principal, founder, and owner was out of his house for 3 to 4 months, couch surfing, trying to find a place to sleep. He was losing employees. There were supply shortages. I'll never forget the sewage backup in Collier County and the smell associated with that. There was flooding everywhere. And Mark DeVries did an excellent job at the trial explaining that it wasn't just the day of the hurricane. There was months afterwards where people were calling saying, there's literally water flooding into my living room. My child is sleeping with a soggy, wet carpet. I mean, we don't have a house to live in. Tri-Town is also an emergency restoration contractor. And again, the testimony was overwhelming. And I would point to the court's function as an appellate court sitting in an appellate capacity. I would point the court to the Sinclair versus Sinclair case from this court in 2002, which explains it is not this court's obligation to, or duty or function to reweigh evidence that was presented at the trial, or to reweigh the credibility of the witnesses that testified at the trial. Particularly relevant to this appeal, where there was a clear alignment at the trial between Ms. Clapperud and Gordon Wild. Mr. Wild made a demand on Ms. Clapperud to cooperate with him in the litigation, was informing her that it wasn't her fault, this situation. All of that evidence was presented at the trial, and both of those individuals were impeached through cross-examination approximately 11 times. And we've cited to that with those materials and that specific impeachment in the briefing. And it is simply not this court's duty, function, or obligation to go back and say, well, I think the evidence should mean this, should mean that. There's a case called Evans versus Thornton from the 4th DCA in 2005 that says it is not this court's function to reject evidence as a matter of law. With respect to Hurricane Irma, I would also point the court to record pages 220 and 221, which is an agreed order on a motion to take judicial notice. Again, that was agreed by Mr. Wild, and the agreed order says or recognizes the devastating impacts of Hurricane Irma, specifically says that all residents of Southwest Florida were impacted by it, and it was months before normalcy was restored to the Southwest Florida area. Mark DeVries testified to the agreed order at the trial and actually said, I think that agreed order is limiting, because it was, and he said at the trial, it was March of 2018 or later until normalcy was actually restored. Then you get to the Nicole Clapperud issue. There is no doubt that Nicole Clapperud was an agent of Mr. Wild. The way that Tri-Town was brought into the project was through Nicole Clapperud. Mr. Wild hired her firm, Design Envy, to come up with drawings. Then Design Envy solicited different contractors to come in and perform the work or submit a proposal. And Tri-Town did that. And that's really how the connection was made. Mr. Wild testified at the trial he did not want to be involved in the construction. And that is the specific reason why he hired Nicole Clapperud and Design Envy and entered into a fixed price contract with Tri-Town. That specific testimony can be found on page 34 of the supplemental record. You also have the undisputed testimony at the trial that Ms. Clapperud was answering questions, responding, actively engaging up to a certain point. And then in November 2017, just after the passage of Hurricane Irma, she starts missing meetings, not being communicative. And I think a very relevant portion of the record for this court to look to is page 199 of the supplemental record, which is an email from Mr. Wild to Tri-Town that says, hello, Mark, the principal of Tri-Town. Nicole emailed, she's meeting with you tomorrow. I know it's frustrating to rely on people only to have them suddenly be unavailable. That's directly from Mr. Wild himself. There was, again, clear testimony at the trial about the impact of Ms. Clapperud's failure to participate in the project, and this court should not disturb that testimony in its role and function today. Another issue with respect to the main appeal is the evidence of damages. completely insufficient. The primary case would be Taylor versus Lee from this court in 2004, which says that the party presenting evidence must justify the award of damages in a definite amount. The case law is clear. Damages cannot be based on speculation, conjecture, or guesswork. The only testimony at the trial about the cost of complete damages was from the subsequent contractor. His name was Ben Corris. He testified it would be $88,500 to perform the work. Tri-Town's initial contract was for $72,900. Tri-Town's testimony was they completed 50 to 60% of the work under the contract. Again, their own expert said Tri-Town completed about $27,000 worth of the work. So, but more fundamentally to the point, there was no documentary evidence whatsoever presented at the trial to support this $88,500. Mr. Corris actually testified that he was going to do the work based on a handshake with Mr. Wild. There was no written contract, no proposal, no budgets, no estimates, no list of subs or suppliers, no project schedule, nothing, not a single piece of paper. He was also disclosed late as a witness, and we objected, and the court allowed him to testify. And even the trial court questioned the sufficiency of the evidence of those particular damages. And the court could look to page 141 of the trial transcript of the supplemental record to review that testimony. The court itself questioned Mr. Corris and said, you know, you're really going to do this work without a written contract in place? And he said, well, that's sometimes how I operate. I do it on a handshake deal. So the lack of written support precludes Mr. Wild sought damages on that particular aspect. Then you have the loss of use, same analysis. All of that we heard at the trial.
Mr. DeVisi, I don't want you to run out of time on the fee issue. Do you want to address that for us on the attorney's fees? And I think your argument here is that because there was a prevailing party provision that the trial court should have awarded your client who prevailed on the original breach of contract claim. And I've got a question on that. We have a case, which is the KCIN case, that says certainly the court here has the discretion to choose not to award any attorney's fees in a prevailing party provision case where the court finds or where the contract shows that both parties were at fault. And so I wanted to know what your response to that is. I mean, couldn't the court here, isn't it apparent where the court awards no one prevailing party fees that the court didn't believe based on the evidence that the court heard that either party should have been entitled to fees?
Thank you for the question. I read KCIN very carefully, and my reading of KCIN is that the court was concerned with a contract that fails in terms of doing the prevailing party analysis. And I have the quote here. It says, prevailing party attorney's fees are just and proper in the majority of contract litigation. We are concerned, however, with contracts that fail as a result of fault by both contracting parties. A rule which requires an award of prevailing party attorney's fees in all cases may result in an unjust reward to a party whose conduct caused the failure of the contract. So my reading of that is there actually has to be a failure of the contract. There was no failure of any contract here. Both parties stipulated there was a valid and enforceable contract, and there was an argument at the trial about whether there was a material breach. In addition to the KCIN, if you look at this court's analysis in Stout Jewelers versus Corson, which is an opinion from this court in 1994, it's directly on point. That case involved a breach of a lease agreement. There was an involuntary dismissal, and it went to appeal before this court about which party was the prevailing party, if any. The trial court.
But is there a distinction? Your adversary here makes a distinction that the cases that deal with dismissals are much different than what we have here. I mean, is that case? I can't remember right off the top of my head if that's a 1.420 dismissal.
Yes, it is, Your Honor, and absolutely a distinction without a difference. It's the principle of law that came from the Corson Stout Jewelers case. There's several other cases, and I'll get to the Carrollwood Cove case. It's directly on point. You also have the Scuddy versus Daniel Architects case, which is from the 4th District Court of Appeal in 1987. That was a dispute between an owner and an architect. The court goes through the analysis. It was an arbitration. The trial court said the architect prevailed for purposes of attorney's fees and costs. It goes up to the 4th District Court of Appeal, and that court essentially uses the analogy of a war versus a battle and says that the primary breach of contract claim is the war and the counterclaim is the battle. So if you look, and I think Corson used that language as well, but they're using the analogy to say it really doesn't matter what occurs on the counterclaim because the counterclaim is the battle and the person or the party who prevails on the primary claim wins the war, and that falls in accord with the significant issues test as articulated by the Florida Supreme Court in Moritz. There's also 2 cases from the 3rd District Court of Appeal, both from the same year, 1983, one called Carew and one called McKelvett versus Kinsey, and they stand for the identical proposition. I would like to address the Carrollwood Cove just because it's very interesting timing. We filed our cross initial brief in this case on April 12th of 2021. Carrollwood Cove was released on April 23rd of that same year. And it's an opinion authored by Judge Sleet of this court. And essentially what happened is the developer sued the association for an alleged overpayment. The association asserted 13 affirmative defenses and counterclaims and also filed a third-party complaint against the board of directors. The association prevailed on the developer's claims. The developer prevailed on the association's counterclaims, and the board of directors prevailed on the third-party complaint that the association had brought. The trial court says the board of directors is the prevailing party for the purposes of attorney's fees and costs, but neither the developer nor the association are prevailing parties. The association appeals. This court, in a very careful, well-articulated analysis, walks through all of the case law that I just mentioned, walks through Stout Jewelers versus Corson from 1994, walks through Scuddy Architects, walks through Moritz, mentions a case from the 11th Circuit called Chow as well, which stands for a similar proposition, and then ends the opinion finding the association to be the prevailing party because the association defeated the developer on its claims and was successful in that regard, regardless of what happened with the association's counterclaims against the developer. So we briefed that case in detail in our cross reply brief because we had the chance to do so after its release. I think it's governing, it's binding. And I've mentioned the other law, particularly Stout Jewelers versus Corson and Scuddy versus Daniel Architects with respect to the attorney's fees and costs issue. I don't think I have any other points to make. We would rely on our briefing. And I think the fee
Before
issue,
you go, counsel, was one of the issues on the cross appeal costs?
Yes, Your Honor. And there is a case from this court called Hawks in 2018 that says it is not the prevailing party standard for the court to apply when addressing costs. It's under 57.041.
It says a party recovering judgment in the statute. Is that correct?
Yes, Your Honor.
In that case, will be consistent with our en banc opinion in Wolf and Culpepper. Is that correct?
Yes.
Just want to make sure that time hadn't passed by the Wolf opinion. I think Judge Kazam had one that was, we cite the most current one. Okay.
I think that was also discussed in a footnote in the Hardman case.
Well, let me ask you this, since obviously you prevailed on one case, you would get cost, and then arguably the other side who got judgment would prevail on that case for cost.
I think that's a fair analysis, and that was my argument to the trial court.
Got it. Thank you so much. I should tell you, if you have anything else, I'll gladly give you a moment or two to sum up because I did ask you a question at the very end that took away your summation time that you might have been trying to hold on to. But we're at 20, so you tell me.
Just very briefly, a primary point for us is the standard this court is to apply. It's the Applegate case from 1979 that says trial court rulings come to this court with the presumption of correctness. Sinclair, I've already discussed from this court in 2002. Evans versus Thornton, I've discussed. There's a separate case called City of Cocoa versus Keffler from the 5th DCA. It just says it is not this court's duty, function, or obligation to reweigh the evidence, reject evidence as a matter of law, or engage in any similar type of analysis. I thank you very much for your time and the opportunity to present today.
Thank you, counsel. Let me stop the clock. So the other part is, and I would like to say before we conclude, I thank both of you for neglecting to remind me that there was a cross appeal here, and I needed to ask Mr. Device whether he wanted to reserve time for his rebuttal on that. But since you've all rolled right through it, I appreciate that. It dawned on me during the presentation, and I didn't want to interrupt anyone because Mr. Mann had said he would go ahead and respond to the counterclaim in his argument. But feel free, particularly if I'm center chair and you have a counterclaim and I didn't ask you, to ask me. I will not be offended. I speak only for me. But, you know, I apologize. I caught that in the middle of the presentation and I didn't want to interrupt anybody about it.
Thank you.
Okay, Mr. Mann, you may use your rebuttal time, sir.
Thank you, Your Honors. I'd like to touch on Carrollwood. Obviously, it's important to the cross appeal here. In Carrollwood, again, we submit that it's distinguishable where this court concluded the association prevailed on the significant issues in the litigation by defeating the developer's second amended complaint. But what the court says specifically is that the final judgment on the second amended complaint, the court ruled the developer failed to satisfy its burden on all counts of the complaint, and that the association had successfully satisfied its burden on 5 of its affirmative defenses. And so, you know, we submit that that's a different situation than what we've got in the case at bar. I again would rely on KCIN, and I also refer the court's attention to a case that we cited in our briefs called Lasco Enterprises versus Colbrand from the 5th DCA, which is at 819 Southern 2nd 821. I would respond to the argument about Atlanta Jet by saying that we would submit that we did not have to have completed the work in order to seek damages, that the law only provides that we had provided a reasonable basis for our calculation of damages, and that was satisfied by the testimony of Mr. Koras regarding the cost to complete and what he testified to, which I already have spoken on. As to Ms. Claproot, again, you know, Mr. Wild hired her as the designer. Her plans on the plans themselves say that these may have to be adjusted by an architect or a plumber. Her scope of her work was limited once she was done with submitting the plans so that Mr. Wild could get a fixed price bid for the contract. Then she was no longer obligated, and the contract, of course, is only between Tri-Town and Mr. Wild. I already mentioned that our calculation on the damages, we obviously reject the suggestion that they were speculative based on what I've already said. I think that's all I have for the court, and we would respectfully request reversal and affirmance as to the cross appeal. Thank you for your time this morning.
Thank you both. I'm glad neither one of you had to come up today from Naples, because you would have found I-75, I-275, and everything, as I did, full of accidents. So I'm glad you're safely there, and I hope you all stay well. And I look forward to hopefully seeing you at a real live oral argument. And I say that on behalf of the whole panel in the future. Thank you very much.
Thank you.
Thank you.
We will move on to our third case.